For 2 years, the fight over AI was company versus company, author versus chatbot, newspaper versus model. But in July, a new fight started, and this one is bigger because it is not about a single lawsuit. It is about who gets to control what artificial intelligence is allowed to say. On one side, the federal government. On the other, 38 states. And the opening shot came from the agency most people associate with scam robocalls, the Federal Trade Commission. Here is what the FTC did. On July 1st, it proposed something it calls a policy statement on the suppression of accuracy in artificial intelligence systems. Read that phrase again. Suppression of accuracy. The argument goes like this. When an AI company quietly tunes, weights, or steers its model to push a hidden agenda, and then sells that model to you as objective, it is deceiving you. And deceiving consumers is already illegal. Under Section 5 of the FTC Act, the same law used against false advertising for a century. FTC Chairman Andrew Ferguson said the agency wants to hear about the subversion of AI systems for ideological ends. On its face, that sounds reasonable. Nobody wants a chatbot secretly lying to them. But look at what the statement actually targets, because buried inside it is a claim that changes everything. The FTC says some AI companies are steering their models not because they chose to, but because a state law made them. And that is where this becomes a war. Rewind to December. President Trump signed an executive order standing up a new Department of Justice task force with one job: challenge state AI laws. The FTC's July move is the second barrel of that same gun. Together, the message to Silicon Valley is blunt. If a state orders you to change your AI's output and you obey, Washington may treat that as breaking federal law. So who are these states, and what did they actually require? 38 states have passed some form of AI law. The one everyone points to is Colorado. Colorado passed a first-of-its-kind law targeting what it called algorithmic discrimination. The idea that an AI deciding your job application, your loan, or your medical care should not quietly disfavor you because of your race, your religion, or your gender. To the states, that is not ideology. That is consumer protection, the exact thing the FTC was built to defend. To the federal government, and to companies like Elon Musk's xAI, which sued over the Colorado law with Washington's backing, forcing a model to hit those targets, is the government putting its thumb on the scale of what the AI can say. Same requirement. Two completely different names. One side calls it fighting discrimination. The other calls it mandated ideology. And here is the irony sitting at the dead center of all of this, an irony even legal experts flagged. The federal government says it wants AI that is neutral and accurate, but who decides what neutral means? If Washington gets to define the one correct, unbiased output, then Washington is now dictating what a private company's software is allowed to say. And that raises a First Amendment problem, compelled speech, that is every bit as serious as the one it claims to be solving. In other words, the cure for government-controlled AI might be government-controlled AI. So, what is actually at stake? 3 groups want control of the dial that sets what your AI will and won't say. The companies who want to set it themselves. The states, who want guardrails for their residents, and the federal government, which just claimed the power to overrule both. Whoever wins, that gets to shape the most influential information technology of our lifetime. Our prediction, on the record. This specific policy statement does not become binding law. It is a proposal, open for public comment until July 31st, and it will be fought hard. But it does something quieter and more lasting. It turns every state AI law into legal quicksand. A company now has to ask, before obeying Colorado, whether obeying Colorado breaks federal law. That uncertainty alone freezes state regulation in place, which may be the entire point. And the real fights? They move to the narrow ground where both parties actually agree, deep fakes and children's safety. Clip this. Hold us to it. What to watch. July 31st, the close of public comment. The Justice Department task force and which state it sues first. And the courts where compelled speech and preemption arguments are about to collide head-on. Because the models are already in 300 million pockets. The only real question left is who gets to hold the leash. And nobody, not Washington, not the states, is reading the fine print for you. Subscribe.